Most people believe the danger in a traffic stop is what the officer can legally do to you. That's not actually where the danger lives. The real danger is what you think they can do, and how that belief changes your behavior before the law ever comes into play. Because here's the shift that just happened, and almost nobody is explaining it clearly. The Supreme Court has been tightening the boundaries around what officers can turn a simple vehicle stop into, and in doing so, they've quietly stripped away one of the most commonly abused extensions of police authority. Not loudly, not dramatically, but surgically. And unless you understand exactly where that line is now, you will walk right past it and hand them power they no longer have. So I want you to anchor yourself to one phrase, and I want it to sit in your mind like muscle memory, because everything we're about to talk about revolves around it. I do not consent to any searches or questioning beyond the reason for this stop. That's the phrase. Not aggressive, not emotional, not argumentative, just precise. And the reason it matters now more than ever is because the law has moved. But police behavior hasn't fully caught up. Picture this. It's late afternoon, you're driving home, maybe a little distracted, maybe a little tired. You see the lights behind you. Your chest tightens immediately, even if you've done nothing wrong. That's not weakness, that's physiology. Your brain floods your system with adrenaline before you've even pulled over. Your hands feel slightly colder. Your thoughts start racing. And by the time the officer reaches your window, you're already operating at a disadvantage. Now the officer leans in, calm voice, casual tone. Do you know why I stopped you? That question feels harmless. It feels conversational, but it's not neutral. It's a doorway. Because the moment you start explaining, guessing, apologizing, you've expanded the scope of the stop yourself. And this is where the Supreme Court's line matters. A traffic stop is supposed to be limited in scope and duration to the reason for the stop. That's not just theory. That's constitutional law grounded in the Fourth Amendment. The stop is justified by a specific violation, and everything that happens is supposed to relate to that. Here's where this gets complicated. For years, officers have been trained to turn that narrow window into something much wider, using what looks like casual conversation but is actually investigative fishing. Questions about where you're coming from, where you're going, whether you have anything illegal in the car. These aren't random. They're designed to create either consent or suspicion. And suspicion is elastic. It stretches. But the Supreme Court has made something very clear in recent rulings. You cannot prolong a traffic stop beyond the time reasonably required to handle the matter for which the stop was made, just to pursue unrelated investigations, unless you develop independent reasonable suspicion. That sounds technical. It's not. It's powerful, because it means the stop has a clock. Not a literal stopwatch, but a legal one. And every extra question, every delay, every pivot away from the original reason has to be justified. Now, this is the part most people misunderstand. Officers don't need your permission to ask questions. They can ask. They can always ask. The Constitution doesn't stop them from speaking. What it regulates is what they can do with your answers and how long they can hold you there to get them. So the real game is not whether they can ask, but whether you will answer. And that's where your phrase comes in. I do not consent to any searches or questioning beyond the reason for this stop. You're not refusing to cooperate with the stop itself. You're not resisting. You're drawing a boundary that mirrors the Constitution. Calmly, clearly, on record. Let me be honest with you. The moment you say that, the tone can change. Not always, but often enough that you need to be ready for it. Because from the officer's perspective, you've just closed off the easiest path, voluntary cooperation. And now, if they want to go further, they have to justify it. And justification is harder than conversation. This is the trap. The entire system is built on making you feel like asserting your rights is suspicious. Like innocence should be talkative. Like only guilty people stay quiet. But the law doesn't say that. The Constitution doesn't say that. That's psychology, not legality. Officers are trained to read behavior, to interpret hesitation, to build narratives quickly. If you're overly nervous, they may see that as a clue. If you're overly calm, they may see that as rehearsed. If you talk too much, you might contradict yourself. If you say too little, they might push harder. There is no perfect performance that guarantees you won't be scrutinized. So the goal isn't to act innocent. The goal is to be consistent. I do not consent to any searches or questioning beyond the reason for this stop. Say it once, say it clearly, then stop filling the silence. Silence feels uncomfortable, especially in that moment. Your brain will urge you to smooth things over, to explain, to be likable. But silence is not obstruction. Silence is control. Now let's walk through how this plays out in real life, because this is where theory meets reality. An officer stops a driver for a broken taillight. Simple, routine. The officer collects license and registration, runs the information, comes back. That's the core mission of the stop. But instead of wrapping it up, the officer lingers, starts asking about travel plans, notices a suitcase in the back seat, asks if there's anything illegal in the car, asks for consent to search. If the driver says yes, everything changes. Consent overrides the need for suspicion. The search becomes lawful based on permission alone. But if the driver says, "I do not consent to any searches or questioning beyond the reason for this stop," now the officer has a choice. Either they proceed with the traffic matter and end the stop, or they try to justify extending it. This is where it turns, because now the officer may start articulating reasons. Maybe the driver seemed nervous, maybe the travel story didn't make sense, maybe there was an odor, maybe something felt off. These are the building blocks of reasonable suspicion. And here's the gray area. Courts often give officers leeway in interpreting these factors. That's reality. Not every assertion of rights leads to a clean, immediate release. Sometimes it leads to more scrutiny. This is the hard truth. Asserting your rights can make the encounter longer in the moment. It can make it more uncomfortable. It can lead to a K9 being called, which introduces another layer of timing analysis, because even a dog sniff cannot unreasonably prolong the stop without justification. So yes, standing on your rights may cost you time. It may test your patience. It may feel like you've made things worse. But what you've actually done is preserve your position if this ever ends up in court. And that's the difference between the roadside and the courtroom. On the roadside, officers have control. In the courtroom, the Constitution does. I've sat through suppression hearings where everything hinged on a few extra minutes, where the question wasn't what the officer found, but how they found it. Whether the stop was extended just a little too long without proper cause, whether the driver consented freely or was subtly pressured into it. And those cases turn on details that are invisible in the moment but decisive later. Let me give you a realistic example. A driver is stopped for speeding. The officer issues a warning, but instead of ending the encounter, continues asking questions. The driver, trying to be cooperative, answers everything. Eventually, the officer asks to search the car. The driver hesitates but agrees. Inside the trunk, the officer finds something illegal. At first glance, that seems open and shut. Consent was given. Evidence was found, but when the case is challenged, the timeline is dissected. The court looks at whether the stop had effectively ended before the consent was requested, whether a reasonable person would have felt free to leave, whether the continued questioning unlawfully prolonged the stop. If the court finds that the extension was improper, the evidence can be suppressed, meaning it can't be used. Now imagine that same scenario, but the driver had clearly said, "I do not consent to any searches or questioning beyond the reason for this stop." That statement becomes part of the record. It draws a line. It forces every action after that point to be justified independently. Do you see the difference? It's subtle, but it's powerful. Now let's talk about body language, because words alone aren't enough. When you say the phrase, your tone matters, your posture matters, your hands should remain visible. No sudden movements, no sarcasm, no hostility. You're not trying to win an argument. You're trying to create a clear, defensible record. Look at the officer when you speak. But don't stare aggressively. Keep your voice steady, even if your heart is racing. And it will be racing. Adrenaline doesn't care how prepared you are. You might feel a surge of fear, a sense that you're doing something wrong by asserting yourself. That's conditioning. Years of social messaging telling you that compliance equals safety. But lawful assertion is not defiance. It's alignment with the Constitution. Now, what if they ignore you? Because sometimes they will. They'll keep asking questions. They'll rephrase. They'll act like they didn't hear you. Or they'll say something like, "If you've got nothing to hide, why not just let me take a quick look?" That's psychological pressure. It's designed to make your boundary feel unreasonable. This is where consistency matters more than anything. You don't escalate. You don't argue. You repeat calmly, "I do not consent to any searches or questioning beyond the reason for this stop." And then you stop talking again. You're not required to debate your rights. You're not required to justify them. You just assert them. Now this is the part that separates understanding from execution. You cannot improvise this under stress. In the moment, with lights flashing behind you, with an officer at your window, with your nervous system in overdrive, you will default to habit. Not knowledge, habit. So if you've never said this phrase out loud before, if you've never felt what it sounds like coming out of your own mouth, there's a good chance you won't say it when it matters, or you'll soften it, or you'll abandon it halfway through. That's why I'm telling you, rehearse it. Not once, not casually. Rehearse it until it feels natural, until it feels like something you can say without thinking. I do not consent to any searches or questioning beyond the reason for this stop, because the law has shifted. The boundaries are tighter than they used to be, but rights that aren't asserted don't protect you in real time. They only exist on paper. And the difference between a routine stop and a life-altering case often comes down to a few sentences, spoken or unspoken, in the span of a few minutes on the side of the road. So don't rely on instinct. Don't rely on assumptions about what officers can or can't do. Anchor yourself to the phrase. Say it calmly, say it clearly, and say it the same way every time. I do not consent to any searches or questioning beyond the reason for this stop. Then let the law do the rest.